My lord, I filed an IE 1860 of 2023 in CRLA 647 of 23. My challenging the order stay or of conviction. But I am given a memo.
Please.
Pardon to mention, my lord. CRLA 314 of 2018 lordship. The petition for return of
Give it.
seized article. Lord.
Please use the mic properly.
ସବୁ କାଗଜପତ୍ର ଆସିଲାଣି ହେରି ଲୋକଟା ଗୋଟେ ଦିନ ଜେଲ ରହିଲାଣି
No. What is the number?
762 CRLA 762
For what purpose? Bail matter. Give it.
I want to mention my own tied up matter of 2022, my lord,
Give it.
custody since last 3 years.
Give it.
Yes, my lord, tied up matter 2022 bill.
এইটা আউটি কে आपके पास ही हो तो এইটা ये जो नहीं आगो येटा हाँ स्पेस आउट जेमती मिली जो एक्स्ट्रा चेयर लगे दे ठीक है
Quickly list item number 1.
yes
My lord, face appeal, my lord. Face
Have you calculated your date of imprisonment? Yes, madam, anything? Yes? Okay. No, this item number, this is Vishwanath Savar.
Yes, madam.
So let us first know that how many, because his sentence is 7 years. So let us know that how many years he is in custody. This is item number JCRLA 6 of 2021, right? Vishwanath Savar. And 304 part 1, 7 years. Then rupees 2000 fine. RI for in default for 6 months.
6 months.
Okay. So first come to the LCR.
Ma'am.
Acha. Final form re देखिला बेलकु आपणकर कस्टडी फर्स्ट कैलकुलेशन करें. Okay, it indicates that you are taken into custody on 3/1/2019. Now, what about the order sheet?
3/1/2019.
No, whether you were released on bail during trial at any point of time, that I am to verify from the trial court record. No, it seems that you were not released on bail. Acha, whether during pendency of the appeal he was granted bail? No. All right. Then that means
UTP trial is there.
So it is 4 years and 7 months. Okay. Let us come to the charge. Paperwork bar karandu.
That.
Charge page 26, na?
26.
Okay, read out the charge.
That on dated 1/1/2019 at about 3:30 p.m. at village Krishnapur under PS Sarango, you committed on murder of informant's father, namely Rabi Sabar.
So the name of the deceased is
Rabi Sabar.
Rabi Sabar, and date of occurrence is 1/1/2019 at about 3:30 p.m. Place of occurrence is village
Krishnapur.
Okay.
Under Serango PS. By assaulting him with a sharp kati.
Okay.
Intentionally with knowledge that death will be caused and hereby.
Now you come to the FIR, page 21. Read out the FIR.
FIR, madam.
Who is this informant? Pushpanjali Bhuiya?
Pushpanjali.
PW?
Front, my lord, PW. PW 437, page 37.
No, ठीक है जी. First you read the FIR. Yeah.
ମୁଁ ପୁଷ୍ପାଞ୍ଜଳି ଭୂୟାଁ, ବୟସ 34 years, ସ୍ୱାମୀ ସନ୍ତୋଷ କୁମାର ଭୂୟାଁ, ଗ୍ରାମ କୁଜାନ୍ସି, ଥାନା ସେରଙ୍ଗ, ଜିଲ୍ଲା ଗଜପତି, ବର୍ତ୍ତମାନ ଠିକଣା କୁମ୍ଭାରସାହି, ଜିଲ୍ଲା ସୋ ଲେଖିବାର ଅଭିପ୍ରାୟ ହେଇଛେ ଗତକାଲି ତା 1/1/2019 ତାରିଖରେ ଆମ ଗ୍ରାମର ସମସ୍ତେ ମିଶି କୃଷ୍ଣପୁର ଗ୍ରାମରେ ବଣଭୋଜି କରୁଥିଲୁ। ସେତେବେଳେ ଅପରାହ୍ନ ସମୟ ପ୍ରାୟ 3:30 ସମୟରେ ମୋର ବାପାଙ୍କୁ କଡ଼ରେ କାମ କରୁଥିବା ସମୟରେ ମୋର ଭାଇ ଜଗନ୍ନାଥ ଶବରଙ୍କ
ବାଡରେ କାମ କରୁଥିବା ସମୟ
ସରି ମ୍ୟାଡାମ ବାଡରେ କାମ କରୁଥିବା ସମୟରେ ମୋର ଭାଇ ଜଗନ୍ନାଥ ଶବରଙ୍କ ଦ୍ୱାରା ଭୋଜି ଖାଇବା ନିମନ୍ତେ ଡକେଇଲି। ମୋର ଭାଇ ଜଗନ୍ନାଥ ଶବର ଓ ମୋର ବାପା ରବି ଶବର ବାଡରୁ ଖାଇବା ନିମନ୍ତେ ଆସୁଥିବା ସମୟରେ ଆମ୍ଭ ଗ୍ରାମର ବିଶ୍ୱନାଥ ଶବର ପିତା ସାନକୁ ଶବର ହଠାତ୍ ପୂର୍ବ ଶତ୍ରୁତାକୁ କେନ୍ଦ୍ର କରି ଏକ ଧାରୁଆ କାତି ସାହାଯ୍ୟରେ ମୋ ବାପାଙ୍କ ବାମ ଗୋଡ଼ ପଛ ପାଖକୁ ହାଣିଦେଲେ ଏବଂ
ତୋତେ ଆଜି ଜୀବନରେ ମାରିଦେବି ବୋଲି କହିଲା। ଉକ୍ତ ବିଷୟ ମୋ ବାପା ଓ ଭାଇ ଜୋରରେ ପାଟି କରିବାରେ ମୁଁ ତଥା ଆମ ଗ୍ରାମର ସୁରେନ୍ଦ୍ର ଶବର, ସୁଦାମ ଶବର, ଲକ୍ଷ୍ମୀ ଶବର ଓ ଅନ୍ୟାନ୍ୟ ଘଟଣାସ୍ଥଳକୁ ପହଞ୍ଚି ଦୌଡ଼ି ଆସିବାରେ ଜଗନ୍ନାଥ ଶବର ଘଟଣାସ୍ଥଳରୁ ଦୌଡ଼ି ପଳେଇଲା ଏବଂ ମୋ ବାପାଙ୍କ ଗୋଡ଼
ବିଶ୍ୱନାଥ ଶବର ଦୌଡ଼ି ପଳେଇଲା ନା। ବିଶ୍ୱନାଥ ଶବର is the appellant. ସିଏ ଦୌଡ଼ି ପଳେଇଲା. Why are you in a hurry?
No.
You are arguing a 302 case which has been turned to 304 part 1. Don't be. Yes.
Pardon.
Yes.
ଅନ୍ୟାନ୍ୟ ଘଟଣାସ୍ଥଳରୁ ଦୌଡ଼ି ଆସିବାରେ ବିଶ୍ୱନାଥ ଶବର ଘଟଣାସ୍ଥଳରୁ ଦୌଡ଼ି ପଳେଇଲା ଏବଂ ମୋ ବାପାଙ୍କ ଗୋଡ଼ ପଛପାକୁ ହାଣି ହୋଇ ଗଭୀର ରକ୍ତସ୍ରାବ ହୋଇ ଗୁରୁତର ଅବସ୍ଥାରେ ସଙ୍ଗେ ସଙ୍ଗେ ପାରଳାଖେମୁଣ୍ଡି ମେଡିକାଲକୁ ନେଇଗଲୁ। ସେଠାରେ ତାଙ୍କର ଚିକିତ୍ସା ଚାଲିଥିବା ସମୟରେ ଗତକାଲି 1/1/2019 ଦୀର୍ଘ ରାତ୍ର ପ୍ରାୟ 8ଟା ସମୟରେ ମୋ ବାପା ମୃତ୍ୟୁବରଣ କଲେ ଏବଂ ମୁଁ ସେଠାରୁ ଆସି ଆଜି 2/1/2019 ତାରିଖରେ ଏହି ରିପୋର୍ଟ ଦେଇ ଅଛି। ଏହାର ତଦନ୍ତ କରାଯାଉ।
Okay. Now who are the eyewitnesses to the occurrence?
Eyewitness ତ ଭାଇ ଜଗନ୍ନାଥ ଶବର ଯାଇଥିଲା ଆଣିବା ପାଇଁ।
Just a minute. Jagannath Savar is PW?
11 madam.
He is the sole eyewitness to the occurrence or anybody else is there? अरे से एकुटिया अछंती ना आउ की eyewitness?
से एका तो जाइत्रा संग आउ केही नाही।
अच्छा, PW 11 Jagannath Savar is the eyewitness. Now we come to the evidence of PW 11. Yes.
PW 11. Page 46. The informant is my elder sister and the deceased is my father. I know this accused Vishwanath Sabar who is standing in the dock. The incident took place on 1/1/2019. On that day, a village feast was organized due to a new year, and after cooking was over at about 2:30 p.m., I went to call my father, who was in the agricultural land, being asked my sister. I was coming in front of him and proceeding towards the spot of feast. On our way, this accused started quarreling with my father and in the process gave a kati blow to the left leg of my father from the behind, causing serious bleeding injury. My father shouted for help and I also joined him in calling the villagers for rescue. Suddenly, the co-villagers gathered at the spot, hearing out of noise. We tied the injury part of a cloth and took him to our house, called ambulance over telephone, and ambulance came late and we took our father to DHH Paralakhemdi for his treatment. And during treatment at about 8 to 8:30 p.m. he died. I was examined by the police and stated the same which I deposed today. In cross-examination, I cannot say the name of the doctor who was treating my father, so also the bed number allotted to him. He was taken to hospital by 108 ambulance, but I cannot tell its registration number. The distance between Demiri Sahi and agricultural land. Demiri Sahi means where the house was there. Demiri Sahi where tara house, ta ghar thara Demiri Sahi. And the agricultural land where my father was working is nearly 100 meters and the spot of feast is nearly 20 to 25 cubits.
Yeah.
The feast was organized in the backside of our house. I cannot say whether my father was inflicted with any other injury above the waist or not. It is not a fact that I was not present at the spot, but in fact I have seen the entire incident. My dress was also stained in blood, but the same was not seized by the police. The weapon of offense and bloodstain earth, so also the tied cloth used on the injury were seized in my presence. The wearing apparels of my father were seized on the spot. It is not a fact that I have not seen the occurrence. It is not a fact that this accused had not assaulted my father by kati, and there was no seizure made by police. It is not a fact that I was all along present at the feast site It is not a fact that I am deposing the falsely, and so incident has taken place.
Okay, so the blow was given by a kati.
Kati,
The place of assault, the portion of the body where the assault was made was the left leg, right?
Left leg.
And let us see the evidence of the doctor who conducted PM
Doctor
exam.
PW 16.
PW 16.
Page 56.
Dr. S.K.SAHOO.
On 2/1/2019, while attached to DHH Parla Committee, I had conducted postmortem on Rabi Sabara, aged about 55 years, in reference to Rayagada PS case number 1/2019, being accompanied by the Constable S.K. Panda. The cause of death of the deceased was due to hypovolemia shock as a result of severe hemorrhage from a wound on left side of leg of size 6 into 3 inch with a rupture of calf muscle and a neurovascular bundle and further and a fracture of a shaft of a fibula. The time of death is within 12 hours of my examination. Exhibit 3 is the said postmortem. Exhibit 13, sorry. Exhibit 13 is the said postmortem report. Exhibit 13(1) is my signature. The injury might have been caused by the sharp and heavy instrument. The nature of injury was sufficient to cause death in all probabilities. Cross-examination. I have not marked any other injury on his body except the injury mentioned by me in my report. It is not a fact that such injury can be possible if someone falls on a sharp cutting glass. The weapon of offense was not produced before me. It is not a fact
It was also not produced during trial.
normal.
You say that I could not seize it.
Second IO is there. The first IO, after retirement of first IO, second IO was engaged.
No, the weapon of offense has not been seized.
Not been seized. Seizeable is second IO sub deny kar diyeche last.
No, it's all right. But so as it appears, it's a case of single blow on the left side leg. And but death was on the very day of occurrence. And the impact of the blow, as it appears, it has caused rupture of the calf muscle, neurovascular bundle, and fracture of shaft of fibula. So, and it is sufficient to cause death. That portion of the body. Okay. All right, we'll hear after lunch. Huh? Okay. That PW11 and PW16. Yes. Any other eyewitness to the occurrence?
Yes, yes, ma'am.
Eyewitness.
PW19 also an eyewitness. You also may kindly say PW19.
1 and 2 also said they have
PW19
seen the occurrence.
Dibakar Sabar.
Rebecca Sabar, my lord. At page 55, I know the informant and the accused who is standing in the dock. This is the father of the informant. The occurrence took place on 1/1/2019. There was a village feast and the deceased was coming to attend from his agricultural land when this accused suddenly assaulted him from his back to his leg by means of a kati, causing profuse bleeding and ultimate death during treatment. I have seen the occurrence. I have seen the occurrence. I was examined by police in connection with this case.
Cross-examination?
I was examined by police on the date of incident at the evening hour when police had come to our village. I took the deceased to his house and then left the place. I have not come to Pallakhamdi hospital. It is not a fact that I had not stated before police anything about the incident. The deceased was an old man. The deceased was not having heart problem before the incident. It is not a fact that this accused had not assaulted Rabi Sawar by Kati, resulting his death. I have not seen his death as because it occurred at the hospital after he was shifted for treatment. The informant is my relative as per village courtship. It is not a fact that I am deposing all false being a relative of the informant.
Okay.
Besides that, your lordship may kindly come to the evidence of PW2, my lord.
1 and 2 also said they
Yes,
have seen the occurrence.
1 and 2 are the also the eyewitnesses?
Yes,
They have seen the occurrence. They have
Just a
certain
minute.
evidence.
1 ala Surendra.
1 Surendra Savara.
Barkala. Ek number sakila.
I know the informant.
Just a minute. Yes, read out.
I know the informant who belongs to the village.
1, 2, 3.
And a seizure also there. I know the informant who belongs to the village Kuja Singh under Sarango PS. This accused is my co-villagers. The incident took place nearly 7 months back. The deceased, named Rabi Sabar, while coming from his agricultural land, this accused suddenly assaulted him by means of a kati to his leg from behind, assaulting serious bleeding injury. I have seen the occurrence with the other co-villagers, who ultimately rushed to the spot, and we all got frightened. Then I with other took the victim to his house and made him sit on the veranda, and then arranging vehicle shifted him to Palakamudi hospital, but he succumbed to his
All right.
injury.
So now at least so many witnesses have consistently stated that what role has been played by the appellant in assaulting the deceased, and on what portion of the body he assaulted, and by what weapon, right? And even the time and place of occurrence is also same in all the evidence of these eyewitnesses.
Yes, ma'am.
Now the question is
And
that
the weapon of offense also produced before the court, and that is marked as MO1.
the doctor also corroborates the ocular evidence of all these witnesses, because he has also noticed one wound of size 6 inch into 3 inch on the left side leg, and cause of death he has opined to be hypovolemic shock as a result of severe hemorrhage. There were rupture of calf muscle, neurovascular bundle, and fracture of shaft of fibula. And the nature of injury has been opined to be sufficient to cause death in all probabilities. Why this learned trial court? Let us see the reason why he has convicted you after acquitting you on 302. Why he has convicted you on under section 304
Part 1.
part 1? So that part has been discussed in which paragraph?
Para 19.
No. Discussion I'm telling. Okay, that I think it starts from paragraph okay, you come to paragraph 18.
Paragraph 8. The division bench of our own High Court, Honorable High Court, in the case of Santosh Topo versus State of Odisha, 2020 SCC Online Criminal 59, has observed where there is a lack of premeditation and motive, and the act is due to the heat of the passion out of sudden quarrel. Exception 4 of section 300 of IPC is attracted, and charge under section 302 of IPC is changed to an act converting under section 304 bracketed 1 of the IPC. This term culpable homicide is defined under section 299 of IPC, and the term murder is defined under section 300 of IPC. In the scheme of the IPC, the culpable homicide is genus and murder is species. Culpable homicide is not murder if the offender committed it without premeditation in a heat of passion, without the offender having taken undue advantage of acted in a cruel or unusual manner. The test of grave and sudden provocation is whether a reasonable man placed in the situation in which the accused was placed would be so provoked as to lose his self-control, mental background created by the previous act of the victim, alias oblique deceased, may be taken into consideration in asserting whether the subsequent act caused grave and sudden provocation for committing the offense. The fatal blow should be clearly traced to the influence of passion arising from that provocation, and not after the passion has cooled down by lapse of time. In analyzing the facts of the case, it is found that the accused was sitting on his outer veranda while the deceased was passing by his side to attend the feast organized in the village. The deceased challenged him as to why he is still continuing cultivation in the agricultural land of his brother, resulting exchange of hot words between them.
Where from the trial court got all these things? That is
the other IO has said, my lord.
In analyzing the facts of the case, it is found that the accused was sitting on the outer veranda while the deceased was passing by his side to attend the feast organized in the village. The deceased challenged him as to why he is still continuing cultivation in the agricultural land of his brother, resulting exchange of
hot
words between them. The accused lost control and in the process brought out a kati from his house and dealt a serious blow to the backside of the left leg. From these attending circumstances, it can well be presumed that there was ill will between them previously, and the act of accused was the outcome of challenge put by the deceased. Ill will and premeditation should be present in the case. Absence of any of them coupled with the important excusing circumstances to transfer the offense into culpable homicide. In the present case, there is, of course, premeditation, but obviously no ill will. In case of so and so, plea of sustained provocation was accepted. Self control is a subjective. No, এই যে পার্টটা যেটা মিস্টার মিশ্র এই যে পার্টটা মানে
None of the witnesses have said.
then how the IO
Lordship, kindly say, only the IO who submitted charge sheet, he has stated, my lord.
he has no personal knowledge. How can this who is that IO?
I am coming to that. Your Lordship may come to page 57, my lord.
57, yeah.
Witness number 21. Is the IO who submitted charge sheet, my lord.
During an investigation?
Yes, my lord. First, on para 1. On 31st 3/2019, I was attached to Rayagada PS. On that day, I received all connected documents in connection with the investigation into Rayagada PS case number 1 of 2019. During course of my investigation, I revisited the spot, re-examined the witnesses, including the complainant, examined the scribe of the affair, and received the original sanction order from the collector Gajpati Pallakhundi during investigation. I made confidentially, this line has come, my lord. I made confidentially inquiry into the incident and found that there was dispute with regard to cultivation in the agricultural land, and on the date of incident, there was exchange and altercation of hot words between them. Being aggrieved, accused Vishwanath Sabar dealt a kati blow on the back of the left leg below the knee joint, resulting profuse bleeding, and the deceased during treatment at DHS Pallakhundi succumbed to his injury. This portion has come. That there was previous enmity.
Is inadmissible evidence. So how can it? What he has confidentially learned, unless the witness comes and
no witness have said it.
PW note 20 declared as a hostile. As one son-in-law of the deceased.
this quarrel part has been, of course, stated by
witnesses, man. There was quarrel.
I think it is 11 has stated like that.
Yes, man.
I was coming in front of him, proceeding toward this spot. On our way, the accused started Haida.
Yes.
On our way, the accused started quarreling with my father. And in that process,
brother of the
any
other
question?
witnesses have also stated.
How kiye koichi dekhibe?
1 and 2.
1 and 2 and 4.
1 and 2.
1 and 2 କୋଉଠି କରିଛନ୍ତି quarrel କଥା?
ନାଇଁ quarrel କଥା କହିନାହାନ୍ତି।
ମୁଁ quarrel କଥା କହୁଛି।
quarrel କଥା କହିନା ସେ ଦେଖିଛନ୍ତି occurrence ବୋଲି କହିଲି। What PW 5 sister of informant. PW 5 ସନ୍ଧ୍ୟା ରାଣୀ ସାବର
କଣ କହିଲେ?
କହିଛି
read it.
The informant is my elder sister. The deceased is my father, and he is accused. And this accused is our co-villagers. The incident took place nearly 8 months back. On that day, on 1/1/2019, we had arranged a village feast, and I was there with nearly all the villagers. After cooking was over, I asked my brother to call my father, who was in the agricultural land. When my father was coming with my brother, who was a little ahead of him, this accused suddenly assaulted him by means of a kati to his left leg and fled away from the spot immediately. Before assault, there was an exchange of hot words between the two. Hearing the noise, we rushed to the spot. This is the one line. Hearing the noise, we rushed to the spot and noticed him on the ground with a pool of blood, which we could not stop from coming out the body in spite of use of 5 towels at the point of injury. We shifted him to hospital in the ambulance. During treatment, he died at about 8 p.m. I was present at the time of the inquest and I identified the body. This is the inquest report, Master Exhibit 4. These are my signatures marked Exhibit 41, 42. This is the dead body challan marked Exhibit 5. This is my signature Exhibit 51. I was examined by the police in connection with this case. Cross-examination. I had read up to 5 class. I cannot say the contents of the inquest report. I put my signature being told by the police. My in-laws' house is at Chikiti Pento. It is not a fact that on 1/1/2019 I was present in my in-laws' house, but in fact I had come for the feast. I cannot say the date of my examination before police. It is not a fact. I was not examined by the police and my statement under section 161 CRPC has not been recorded. My above statement was told by me before the police, now before the court. I do not have any direct knowledge relating to.
So he has also no direct knowledge.
You Lakshman kindly should place for the PW 14 mallet.
14.
14. Page 49.
Hmm.
I know both the parties of this case, including the deceased. The incident took place in the New Year day, that is 2019, and at that time, village feast was organized in the afternoon. After taking my meal, I came to my house, and after sitting for 5 minutes, I heard a large noise of villagers. I rushed to the spot and found this accused assaulting Ravi Sabar. He was shifted to DSS Parlakhandi in an ambulance, that is cross insolvent. The deceased had sustained bleeding injury on his backside of his leg and he was suffering from profuse bleeding. I have not seen any other injuries over his thigh. I had not gone to the hospital. I have not seen the weapon of offense on which the accused assaulted the deceased. It is not a fact that I have not seen the occurrence and the accused has not committed murder. I have come today with the police people. It is not a fact that I was not instructed by police to tell all these facts. It is not a fact that this accused had not ascertained the deceased, resulting in his death.
Very clear. Now you see, if you want to convict somebody under section 304 part 1, then this section requires that it is to be proved that it's a case of culpable homicide not amounting to murder, and act by which the death was caused was with the intention of causing death or of causing such bodily injury as is likely to cause death. So, culpable homicide not amounting to murder is defined under these explanations. There are 5 exceptions, and so far as murder is concerned, it is stated that the culpable homicide is murder if the act by which death is caused done with the intention of causing death. If it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death of the person to whom harm was caused, if it is done with intention of causing bodily injury of any person and the bodily injury intended to be inflicted is sufficient in ordinary course of nature to cause death. If the person committing it knows that it is so eminently dangerous that it must in all probability so and so. Okay. Now the doctor's opinion indicates that it's a very
Question has been put by the defense whether this type of injury in ordinary course of nature is fatal, and
no, the doctor has stated positively that sufficient to cause death in all probabilities.
yes, ma'am.
Nothing has been, I have not marked any other injury. That's it. Not a fact that such injury can possibly sound relevant. The open of offense was not produced before me. It's not a fact that my report was not based on any scientific reason. This is dietary failure of fluid. Because as it appears, he was immediately also shifted to the hospital.
And same day evening he died.
In an ambulance, and he was taken to DHS Parla Kemundi, and on that day itself he died. Have you brought any decisions on that if the assault is on the back of the left leg and the injury is caused and ultimately death occurs? It would not be 304 part 1 or part 2. It may be grievous hurt. Have you brought any decision to that, right? Suppose somebody amputes the left leg, still then a person can survive or not? Somebody amputes the hand, whether that person can survive or not.
Can survive.
So question is that the what murder requires, that definition is, apart from other things, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death. Because offender had a kati with him, he could have very well assaulted on the head, vital part of the body, could have pierced in the chest of the deceased. But he is omitting those vital parts. He is focusing on the leg, that to backside of the leg, and that to a single blow. So obviously the part of the body selected, whether it can be said that he was knowledge that my blow would cause the death of the deceased. The next one, 300, says that if it is done with the intention of causing bodily injury to any person, and bodily injury intended to be inflicted is sufficient in ordinary course of nature to cause death. So the doctor, the nature of injury is sufficient to cause death in all probabilities. Of course, no question has been put. That is the main problem.
No question has been put by the defense one.
The problem is that state defense counsels are engaged without any experience.
And that too, my lord, so far the 313 statement is concerned, the Lordship may see that he has not taken, the accused has not, the appellant has not taken any specific plea, my lord. Only stated that
No,
due to
we are not disturbing the finding that there was an assault. The assault was made by a kati. That was
a
the
single blow.
Single blow. Author is the appellant.
Yes.
Portion of the body is the back of the leg.
Yes.
Okay, all these are, but question is that the part of the body where the assault was made, whether
vital part of the
whether it would be a vital part of the body, and the injury was intended by inflicting such blow to cause death. So, or just to make him crippled so that he cannot walk throughout the life. That would cause him under grievous assault. Grievous assault by a dangerous weapon. So obviously it would come under 326 of the Indian Penal Code.
But the same day, in the evening, my lord, the deceased died.
No, there is.
Died
You see,
immediately. Or that stayed
there
in
is
the hospital.
suppose if he advances any argument that if better treatment would have been provided to the deceased in a specialized hospital immediately, then there was chance of survival of the deceased. That
No
cannot.
question is
No. That cannot be a ground. That say a specific clause is there. Come to section 299, explanation 2.
Where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented.
ତେଣୁ ମନେ କରନ୍ତୁ ଗୋଟେ ଗାଁରେ ଗୋଟେ ଘଟଣା ହେଲା, ଆପଣ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ଯେ ଆଜ୍ଞା ଯେ ତାକୁ ଆଣିକିନି ଭୁବନେଶ୍ୱରରେ କି କଟକରେ ଏସସିବିରେ ଇମିଡିଏଟଲି ଭର୍ତ୍ତି କରିଦିଆ ପାରିଥାନ୍ତା, ତାହେଲେ ହୁଏତ ସେ ବଞ୍ଚି ଯାଇଥାନ୍ତା। ତାକୁ ନେଇକିନି ପିଏଚସିରେ ପୁରେଇଲେ, ସେଇଠି ଟ୍ରିଟମେଣ୍ଟ କଲେ। ତେଣୁ ଏଇଟା କୁହାଯାଇ ପାରିବନି ଯେ ଇଟ୍ସ ଏ କେସ୍ ଅଫ୍ କଲ୍ପେବୁଲ ହୋମିସାଇଡ୍। So they say no, it's not like that.
But here hospital is the district headquarters hospital.
No, it's not. So you cannot advance such a ground. That is why ସେଗୁଡାକ exclude କରିଦେଲେ ଯେ ଯୋଉଠି ଯାହା ଫ୍ୟାସିଲିଟି ଅଛି ଆଭେଲେବୁଲ ଅଛି ସେଇ ଅନୁଯାୟୀ ସେମାନେ ଟ୍ରିଟମେଣ୍ଟ ହେଲେ। So question ହଉଛି ଯେ ତମେ what is your intention, what role you have played, how you have acted, what is the background, what is your immediate prior to the assault, what was your conduct, and after your assault, what was your conduct. So all these factors are important. So ethi evidence asi jaichi je there was a quarrel, and during that quarrel a single blow was given and with a kati, and the vital part of the body have not been touched. That means from the जो बटकरू जदि आमे ऊपर उठे दवा से पोर्शन ने टच हेनी। गोटे गोडर लेफ्ट लेग रो तळ आडकू मराटा हेछि, बट तार इफेक्ट कोन हला ना इफेक्ट हेछि जे प्रोफ्यूज ब्लीडिंग हला, रप्चर ऑफ द काल्फ मसल हला, आउ फिबुला फ्रैक्चर करियला। That was the why didn't you search for the decisions? How you develop yourself? When we are also getting jail criminal appeals, we used to prepare written note of argument, bring citations, and argue the matter as if it's a criminal appeal. It's not that we have dearth of criminal appeal with us. So many criminal appeals were there, but in spite of that, sometimes these jail criminals appeals were given to us, death reference cases or other cases. But the preparation was to that standard. It's not that where. So unless you do that, you cannot develop yourself.
In this case, scriber has not been examined. Scriber of the affair.
Leave those portion. What are you selling? eyewitnesses are there, scribe not examined. Is it a ground? How can you get over the statement of the eyewitnesses? One witness version, if it is acceptable, appears to be truthful, conviction is sustained. It's not necessary that the prosecution would go on examining number of witnesses to prove a case. Because once you examine number of witnesses, number of contradictions will also be there. And scribe of the FIR is not examined. Is it a ground for acquittal in a 302 case? The that has FIR has been the person who is the lost the FIR, he has proved the FIR. IO has stated that on this basis the investigation was carried out. So there is evidence that the FIR was lost and by this person, then the investigation was set into motion.
Moreover, my lord, forensic laboratory report is also there where blood was found.
Now that in that where?
Page 63.
No, you said that the weapon of offense was not seized.
Weapon of offense also
Seized, madam.
Oh, weapon of offense was also seized.
Yes, ma'am.
But it was it was not produced during trial.
MO was produced and marked as MO.
Oh, then MO mark ହେଇନି?
Mark is MO1.
ମନା କରୁଛନ୍ତି କଣ ଆପଣଙ୍କର preparation? You made a submission that the weapon of offense was not produced during trial. He says that it is MO1. That Kati.
Yes,
Let us come to the judgment. Judgment. Over. MO1 is the weapon of offense.
Yes.
Sure. And the query must have been made also with reference to the I was not stated that after the seizure of that MO.
Yes, ma'am.
Who is that
Exhibit 7 is the seizure list, my lord. That is
no, that is the seizure list of that weapon. No, it must have been sent to the medical officer, or it has not been sent for his opinion.
For the FSL Barampur, it has been.
No, FSL. No, I am telling about the to the doctor who conducted PM. There it is sent for whether the injury which is there on the deceased, whether it is possible by such weapon or not.
The doctor has stated the weapon of offense was not before use.
Doctor has not stated anything with reference to that weapon.
Yes.
Was not produced before me. Weapon of offense was not produced, doctor has stated.
That was sent to forensic laboratory, regional forensic laboratory.
এটা তাহলে বইটা তাহলে একটু 2 নম্বরটা দিয়ে manual air manual 304 latest manual on air manual. AR manual नुआ ला 304 जो तक थी वो धरिकी आसो फोन करो ताको से नहीं आसो लाइब्रेरियन give him a ring immediately within 2 minutes he should come.
May I please, my lord, the observation made by the learned trial court about that weapon of offense, my lord. Para 16, the bottom 5 lines, my lord.
Yes.
Para 16. There is no dispute that the deceased was an old man and not having any heart problem. Besides that, the nature of evidence required to lend assurance to the testimony of the informant is very much present, and the doubt that occurs in the mind cannot, in any stretch of imagination, be called as reasonable. The seized weapon of offense, sample earth, bloodstained earth, and the wearing apparels were produced before the court, and it is found that the kati, that is MO1, with wooden handle, is a sharp cutting one, and in any blow on the said kati can destroy the life of the individual.
This exhibit 13 postmortem report.
Well,
Where is that exhibit? What is the exhibit list? PM report version. This is not PM report. This PM report, Mr. Mishra, it reads like this, that deceased so-and-so is a male person, okay, then rigor mortis present, then size is 6 inch into 3 inch into so-and-so. The calf muscle, then this fracture of fibula is there, then cause of death is due to hypovolemic shock as a result of severe injuries from so-and-so. Injury could have caused by sharp cutting weapon.
Exhibit 13 for PM.
So this PM report is totally silent, that this particular last line which he has stated about that injury is sufficient to cause death, that is not there in the PM, that report. That
but that is not brought on record by the defense during examination, cross-examination to any of the witnesses.
No, any of the witnesses.
Not even to the doctor.
Doctor's evidence is there that the
He has stated,
injury is sufficient to cause death. The PM report is also marked as an exhibit. PM report, there is nothing that injury sufficient to cause death. जो এটা বন্ধ করে এটা यदि बात करो ये गूगल बात है write down hypothalamic shock one hypothalamic shock मारा PO volemic VO हाँ hypovolemic shock is an emergency condition in which severe blood or other fluid loss makes the heart unable to pump enough blood to the body. This type of shock can cause many organs to stop working. Okay. You make it half up. You can mojia answer. That's it though. 8 of extend karo. 8 of extend karo yadu. एटा स्क्वीज करो टी सब देखा जिवो जेम कंप्लीटली ना पूरा पेज टा देखा जाउनी ओके फ्रैक्चर ऑफ shaft of fibula ओके टेक डाउन एटी shaft of fibula हमारा of fibula FIB ठीक है shaft of fibula shaft of fibula fracture हमारा लेक्का से fracture असर fibula fracture commonly occur as a part of the ankle injury. These injuries occur in a similar manner to badly sprained ankle. ये जो आंठू तळुकू सवा लास्ट को गोइठी भितर से पोर्शन टा रे गोटे साइड रे फ्रैक्चर that is fibula fracture कहते है ना fibula fracture commonly occur as a part of ankle injury. These injuries are common so and so to a badly sprained ankle, which most injuries are treated in the same way as sprains. Treatment for this type of fracture is a walking boot. Fibula is not a weight-bearing bone. Your doctor might allow you to walk as the injury recovers. You also might be advised to use crutches, avoiding weight on the leg until the bone heals because of the fibula's role in ankle stability. এটা is that the line between the culpable homicide not amounting to murder and grievous hurt is a very thin and subtle one. In the former case, the injury must be such as are likely to cause death, while in the latter, they must be such as endanger to life. ତେଣୁ ଜୀବନ ପ୍ରତି ବିପଦ ଅଛି ଏଇ ଟାଇପର ଇଞ୍ଜୁରିରେ ସେଟା ଗ୍ରିଭିୟସ୍ ହର୍ଟ ହବ କିନ୍ତୁ ଏଇ ଇଞ୍ଜୁରି ଏଭଳି ଯେ ମୃତ୍ୟୁର ସମ୍ଭାବନା ଅଛି ଏ ଯୋଉ ଇଞ୍ଜୁରି so that sort of injury is required for culpable homicide not amounting to murder.
Year 26, my
You
lord.
see, it is Supreme Court decision 92 Supreme Court 141, where the participation of the accused in the occurrence which resulted in death of one person had been proved beyond doubt, and 13 injuries were found on the dead body of the deceased. Out of those, 11 were on the lower legs and arms. It could be said that the intention of the accused was to cause grievous hurt, and as such the offence committed by them would come within the parameters of section 325 of the IPC. Conviction under section 304 part 1 would be liable to be set aside. Decision ଖୋଜିଲେ ମିଳିବ ହେଲା ଯୋଉମାନଙ୍କର ପଇସା ନଥାଏ
Here sentences has been
ସେମାନେ
passed, my lord.
ସେମାନେ ହିଁ ଜେଲ୍ କ୍ରିମିନାଲ ଅପିଲ ଫାଇଲ କରନ୍ତି ତେଣୁ ଆପଣମାନଙ୍କୁ ଯୋଉ ଗୁରୁ ଦାୟିତ୍ୱ ଦିଆହେଇଛି merely because you are not getting that much amount which you might be getting while arguing a criminal appeal, your interest, your participation, that should be always there. ତାକୁ ମାନେ ନିଜର ସବୁ କିଛି ଲଗେଇ ଦେବେ with to see that he gets justice. And when a poor man comes to this court and unable to engage, file a criminal appeal or engage a counsel of a good counsel who is well versed in criminal law, then it is the duty of the state and also the duty of the court to see that a good counsel is provided to him. That is why in 302 case they are telling that a person, at least a counsel who is having 10 years of practice and well versed in criminal law, he should be appointed. Now, if you will not go through the citations, if you will not go through the manual, how can you get it? ସେ ଡିସିସନ ମାଇଲ କି କଣ ତମକୁ ବି କହିବାକୁ ପଡିବ ହଁ କଣ ଡିସିସନ ମୁଁ କହିଲି 141 you have not taken down it. Why are you sitting here then? What is the purpose? I'm just coming within 2 minutes to call ask him. I'm dictating the judgment. Full page chronologies. JCRLA number 6 of 2021. The appellant Vishwanath Savar faced trial in the court of Additional Session Judge Parla Khemuli in ST number 16 of 2019 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 1/1/2019 at about 3:30 p.m. at village Krishnapur under Serengo police station, he committed murder of father of the informant,
Ravi Shankar.
Ravi Shavar, hereafter the deceased, by assaulting him with a sharp kati intentionally with knowledge that death will be caused. The Lennon Trial Court, by judgment and order dated 19/10/2020, has been pleased to hold the appellant guilty under section 304 Part 1 of the Indian Penal Code and sentenced him to undergo rigorous imprisonment for 7 years and to pay fine of rupees 2,000 in default to suffer RI for the period of 6 months. The prosecution case, the prosecution case as per the first information report lodged by Puspanjali Bhunya, bracket PW4, in short is that on 1/1/2019, during daytime, on the eve of New Year, the villagers were organizing a feast in village Krishnapur. At about 3:30 p.m., the deceased was the father of the informant. Was engaged in repairing the fence and he was called to attend the feast by the informant by sending her brother Jagannath Savar, bracketed PW11. While PW11 and the deceased were coming to attend the feast, on the way, the appellant on account of previous dispute assaulted the deceased by means of a sharp kati on the back of the leg. Hearing the shout of the deceased as well as PW11, the villagers rushed to the spot and seeing them, the appellant decamped from the spot and the deceased was found to have sustained serious bleeding injuries on the leg, for which he was immediately shifted to District Headquarters Hospital, Patamundi, Paralakemundi. While undergoing treatment in the hospital, the deceased died at about 8 o'clock, 8 p.m. The report was presented by PW4 on 2/1/2010 before the inspector in charge of Rayagada police station, and accordingly Rayagada PS case number 1 of 2019 was registered under section 302 of the Indian Penal Code against the appellant.
Affair was lodged, my lord, on 2/1/2019.
2-1. No. Occurrence took place 1-1, but
हाँ.
affair was 2-1.
2/1/2019 तो 10 कर दिली मुझे उठा दिली 2019. Who is the IO?
IO is 15 and
First IO is
first IO is 15.
15.
Second IO 21.
21.
Okay. On the registration of the case, the IIC directed PW15 Karunakar Sahu was attached to Rayagada police station as SI of police to take up investigation of the case. During course of investigation, PW15 examined the informant bracket PW4 took steps for guarding the dead body of the deceased and visited the spot, examined material witnesses, arrested the appellant on 3/1/2019. Stop. On the basis of the statement of the appellant, the weapon of offense, that is sharp cutting kati, was recovered from paddy bag, from a paddy bag, and it was seized
In presence of PW6.
in presence of witnesses, and the charge of investigation was handed over on 30/3/2019 due to Kagudiyala
PW
21. Below 21.
to
He has only submitted charge sheet.
to PW21 Ratna Nidhi Patra. अच्छा सी जो ये टहला सी किस कोई एविडेंस ये आ रहा है उटा कितने नंबर जो प्रथम आई उटा
PW 15. PW 15.
अच्छा the appellant was sent for ସେଇଠି ଲେଖିଦେବେ ତାର ଯୋଉ appellant arrest ହେଲା ନି recovery ହେଲା ନି the appellant was sent for medical examination. Inquest over the dead body was conducted, and it was sent for post-mortem examination, and PW15 received the post-mortem report. He made a query to the doctor conducting post-mortem examination regarding possibility of injury with the weapon seized at the instance of the appellant, and received the report. The wearing apparels of the appellant were also seized. And then the charge was handed over to him. So PW21 Kupalaya Sundu was also the SI of police Kasinapur police station, no, Rayagada police station. He also revisited the spot, re-examined the witnesses, and received the sanction order from the collector Gajpati Parla Kemundi. And on completion of investigation, found prima facie case against the appellant and accordingly submitted charge sheet. Charge sheet টা দেখলে LCR টা দেখো। Under section 302 of the Indian Penal Code and section 25 bracketary 1A of the Arms Act against the appellant. What is the accused statement? The defense plea is one of denial, and it is stated that on the date of at about 4 p.m. while he was returning home from his work, police arrested him and implicated him in a false case. He further stated that there was no dispute with the deceased prior to the occurrence. In order to prove its case, the prosecution examined 21 witnesses, exhibits, then no witness was examined on behalf of the defense. The London trial court, after assessing the oral as well as documentary evidence on record, has been pleased to hold that though the weapon of offense was not produced before the doctor who conducted post-mortem examination, but his report is based on scientific reason. It was further held that the injury which was caused on the deceased did not cause his instantaneous death. And it was not on the vital part of the body. And not in all probability will cause death. Such an injury also does not exhibit the intention of the attacker in causing death of the deceased. But the knowledge of the attacker as to the likely consequence of such attack, which could be none other than causing death. It was further held that so far as knowledge is concerned, it can be attributed that the appellant was having enough knowledge to the act he committed, so also its consequence and the intention to commit the same can be gathered from attending general circumstances of the case. It was further held that from the attending circumstances, it can well be presumed that there was ill will between them previously, and the act of the appellant was the outcome of challenge put by the deceased. Ill will and premeditation should be present. And in the present case, there is, of course, premeditation, but obviously no ill will. Lennon trial court seems to have relied upon the confidential report of the investigating officer and has been pleased to hold that though there is lack of positive evidence to show that there was grave and sudden provocation at or about the time of occurrence, but relying on the confidential report. It was held that the act of the appellant has direct nexus from which it can be safely said that the appellant, with the intention of causing death, had inflicted a blow by means of sharp-edged kathi, with the knowledge that in all probability, considering the age of the deceased, it will cause death. And accordingly, it was held that the appellant is responsible for committing culpable homicide not amounting to murder, and convicted him under section 304, part 1 of the Indian Penal Code. Eight and Mr. Devendra Naran Patnaik, Land Counsel appearing for the appellant, contended worry that FIR was scribed by somebody else. You made a submission. Who has stated that?
Scribe.
Who has stated that it was not the informant?
Informant. Informant.
Where he has stated?
In cross-examination, he has stated. In cross-examination.
Rule 4 cross-examination.
Rule 4. It is not a fact that our village has been divided into 3 fields. It is not a fact that village feast was held in Krishnapur village. I have read up to 7 class. The affair was scribed at the police station as per my dictation. I have gone through it and then signed on this.
So it's not somebody else who has scribed the FIR. It is the police who has scribed the FIR. He orally reported it. The police reduced it to writing. And it was read over and explained to him. And that IO, the first IO is, or IIC has been examined.
15. First IO 15.
No.
In the
First IO is PW?
Next
15.
Next line also mentioned on the body of the affair. The name of a scriber has not been found less. So also his endorsement.
The IIC KK Murmu has not been examined.
No, KK Murmu.
Stated that though it is the informant's case that the FIR was scribed at the police station on her dictation. But on the body of the FIR, the name of the scribe is not there, so also his endorsement. On the other hand, PW15, the first investigating officer, has stated that PW4 presented a written report before the IAC KK Murmu. The Land Council further submits that in view of the part of the body where the assault was made and the nature of injury caused, it cannot be said that it's a case of culpable homicide not amounting to murder. And therefore, the conviction of the appellant under Section 304 Part 1 of the Indian Penal Code is not proper. It is further argued that the appellant was taken into judicial custody on 3/1/2019 and he was never released on bail during trial and during pendency of the appeal. And therefore, he has already undergone substantive sentence of 4 years and 7 months. And it may be a case of under Section 326 of the Indian Penal Code, and the sentence of the appellant be reduced to period already undergone. Land Counsel for the state, Mr. Manojan Mishra, and on the other hand, supported the impugned judgment and contended that the Dr. PW bracket 16 has specifically stated that the cause of death of the deceased was due to hypovolemic shock as a result of severe hemorrhage from the wound on the left side leg. And the impact of the assault was such that it had caused rupture of calf muscle and neurovascular bundle and fracture of shaft fibula. The Land Council submitted that the weapon of offense was a kati, na?
Kati.
A kati, and
Wooden handle kati.
it was recovered at the instance of the appellant from its hidden place, basing on the statement
PW6.
of the appellant, and the weapon was sent for chemical analysis, and the C report indicates that human blood was found on it. The Land Council further submits that the eyewitnesses are consistent that it is the appellant who during quarrel assaulted the deceased on the back of his leg, causing injury, and the deceased was immediately shifted to the district headquarters hospital, Parla Khemundi. But in spite of treatment, he died on the very day, and the evidence of the eyewitnesses has not been shaken at all in the cross-examination. Therefore, the criminal appeal being devoid of merit should be dismissed. Adverting to the contention raised by the Land Council for the respective parties, it appears that there are number of eyewitnesses to the occurrence, and one of the most important eyewitness is none else than the son of the deceased, who has been examined as PW11, and he stated that on the day of occurrence, that is 1/1/2019, a village feast was organized on the eve of New Year, and after the cooking was over at about 2:30 p.m., he went to call the deceased on being asked by his sister, bracket PW4, and while he was coming to the place of feast, on the way the appellant started quarreling with the deceased, and in the process gave a kati blow to the left leg of the deceased from the backside, causing serious bleeding injury. He himself, so also the deceased, shouted for help, for which the co-villagers rushed to the spot, and they tied the injury part in a cloth and took the deceased to his house, and then an ambulance was called, which came late, and the deceased was taken to district headquarters hospital, Parla Khemundi, for his treatment. But during treatment at about 8 to 8:30 p.m., he died. In the cross-examination, no question has been put on the assault part. Except that the deceased was not assaulted on, has not been inflicted any injury above the waist. The evidence of PW 11 has remained unchallenged. The other witnesses to the occurrence are PW 19, PW 1, and PW 2. PW 19 has specifically stated that there was a village feast and the deceased was coming to attend the same when the appellant suddenly assaulted him from his back to his leg by means of a kati, causing profuse bleeding and ultimate death during treatment, and that he has seen the occurrence. In the cross-examination, it has been elicited that the deceased was an old man. He was not having any heart problem before the incident. PW1 has also stated about the assault made by the appellant by means of a kati to the back of the leg, causing serious injury. And in the cross-examination, it has been elicited that the deceased was an old man, aged about 60 years. Nothing further has been elicited in the cross-examination. PW2 is another eyewitness who has also stated that the appellant assaulted the deceased by means of a kati, causing profuse bleeding. And after assault, the appellant ran away, and the deceased was taken to District Headquarters Hospital, Parla Kemundi, where he died on being succumbed to the injury. He has denied the suggestion made by the London Defense Counsel that the deceased died due to heart problem and not by the assault of the appellant. Therefore, on a conjoint reading of the evidence of all these eyewitnesses, that is PW 11, PW 19, PW 1, and PW 2, it appears that while the deceased was coming to the place of feast on being called by PW 11, on the way, the appellant quarreled with him, and during such quarrel, he assaulted the deceased on the backside of the leg by means of a kati and ran away from the spot. The evidence of the IO, first IO PW
15.
first IO bracket PW 15 indicates that after the appellant was arrested, at his instance, the weapon of offense, that is sharp cutting kati, was recovered from paddy bag, and it was seized in presence of the independent witnesses. And it was sent to RFSL Berhampur, and the opinion has been given that the kati was having human blood stain of group B. The wearing apparel, that is a blue color half t-shirt of the appellant, was also seized, and it was found on chemical examination to have contained human blood of group B. The doctor who conducted post-mortem examination has been examined as PW16, and he stated that he noticed one injury of size 6 inch into 3 inch on the left side leg, and he opined the cause of death was due to hypovolemic shock as a result of severe hemorrhage from the wound, with rupture of calf muscle and neurovascular bundle and fracture of shaft fibula. The doctor has further opined that the injury might have been caused by sharp and heavy instrument, and he has proved the post-mortem report marked as Exhibit 13. He has denied the suggestion given by the London Defense Counsel that the deceased died due to failure of act. The doctor, of course, has stated that the weapon of offense was not produced before him. However, he stated that the nature of injury was sufficient to cause death in all probabilities. On perusal of Exhibit 13, the post-mortem report, it appears that there is nothing on it to show that the nature of injury was sufficient to cause death. Therefore, from the evidence adduced by the prosecution, it appears that the author of the injury on the deceased is none else than the appellant, and it was caused by a sharp cutting weapon, that is kati, and as a result of the injury sustained on the left leg, there was rupture of calf muscle and neurovascular bundle and the fracture of shaft of fibula. Now the question comes for consideration as to whether the conviction of the London Trial Court under section 304 part 1 is justified, or it would be a case of voluntarily causing grievous hurt by a dangerous weapon punishable under section 326 of the Indian Penal Code. Culpable homicide has been defined under section 299 of the Indian Penal Code. So, it consists in the doing of an act bracket re choto a with the intention of causing death, b with the intention of causing such bodily injury as is likely to cause death, c with the knowledge that the act is likely to cause death. Intent and knowledge as the ingredients of the section 299 postulate the existence of a positive mental attitude, and this mental condition is the special mens rea necessary for the offense. In what cases culpable homicide would be murder has been enumerated under section 300 of the Indian Penal Code. If it falls within any of the four clauses as mentioned in the said section, then it will be a case of culpable homicide. That case of culpable homicide would be murder. However, if it falls within any of the exceptions, 5 exceptions enumerated under the said section, it would be culpable homicide not amounting to murder. Which is punishable either under section 304 part 1 or 304 part 2. The distinction between part 1 and part 2 of 304 IPC is that when it is proved that the accused had the intention to cause such bodily injury as is likely to cause death, the offense committed is punishable under Section 304, Part 1 of the Indian Penal Code. And if the accused has no intention but has knowledge that the act done is likely to cause death, or to cause such bodily injury as is likely to cause death, it would be punishable under Section 304, Part 2 of the Indian Penal Code. In the case in hand, prior to the assault, the evidence on record indicates that there was quarrel between the appellant and the deceased. And even though the appellant was armed with a weapon like kati, but he has not assaulted to any vital part of the body, but gave a single blow on the back of the left leg and left the spot. No doubt such injury has caused rupture of calf muscle and neurovascular bundle and fracture of shaft of fibula. But by causing such injury, it cannot be said that the act was done with the intention of causing such bodily injury as the appellant knew to be likely to cause death of the deceased. And it was done with the intention of causing such bodily injury to the appellant, and the bodily injury intended to be inflicted was sufficient in ordinary course of nature to cause death. It cannot be lost sight of the fact that the doctor's statement that the nature of injury was sufficient to cause death in all probabilities is not there in the post-mortem report exhibit 13. Se বইটা দিও। When the appellant was having a weapon like kati, there was scope and opportunity for him to cause injury on the vital part of the body, but he has not done the same. কোন এটা কোন বার করেন এটা বার করলাম criminal law journal hmm. 1992 1992 কোন বার করছেন then page number question 3939 in the case of Parshuraman and others versus state of Tamil Nadu, reported in AR 1993 Supreme Court 141 দিয়ে বইটা দিয়ে 93 Supreme Court 141 and that is 1992 Criminal Law Journal 3939 ହେଲା where participation of the accused in the occurrence which resulted in the death of one person was proved beyond doubt, and 13 injuries were found on the dead body of the deceased, out of which 11 were on the lower legs and arms, comma, it was held that the intention of the accused was to cause grievous hurt, and as such the offense committed by them would come within the parameter of section 325 of the Indian Penal Code. এটা ভার করো citation search এটি আসো 1994. Then 1544. In case of Motilal versus State of Madhya Pradesh, reported in AIR 1994 Supreme Court 1544. It was held that the appellant inflicted only one injury with an axe. And since it was found that it was not found to be sufficient in ordinary course to cause death, the conviction would be under section 326 of the IPC, as the injury was caused with deadly weapon like axe and the injury was likely to endanger life. And accordingly, the conviction of the appellant under section 304 part 1 was set aside and he was convicted under section 326 of the Indian Penal Code. It is so. Crimes bar करो. 1994 करो, है ना? तापरे वॉल्यूम करो 2, पेज 621. 621. नहीं किसी ये বইটা আনিব 1994 ভলিউম 2 ক্রাইমসটা 621 হ্যাঁ in the case of so and so देखिए ना আসলে লিখো है ना reported in 1994 volume 2 crimes 621. It was held that where the accused had not repeated the blow and had given and has caused one injury only on the left leg of the victim with a kulhadi, it could not be said that the accused had even remote knowledge that injury with kulhari on the lower portion of the leg of the victim would result in his death, and accordingly, the conviction of the accused under Section 304 Part 2 was altered to one under Section 326 of the Indian Penal Code. Contact. 93 ପ୍ରଥମଟା ପାର୍ଟି ନାଁଟା ଦେଖିଲେ ମୁଁ ଯୋଉଟା କହିଥିଲି ଠିକ ଅଛି ତ 93 ସୁପ୍ରିମ କୋର୍ଟ 141 ପାର୍ଟି ନାଁ କଣ ଥିଲା ହଁ କୁଲଦୀପ ସିଂ ଡାକିଥିଲେ ନା ଠିକ ଅଛି ରକ୍ତ ଆଉ ବାକି ଗୋଟା ବହି ମଗେଇ ଦିଅ In view of the foregoing discussions, when the evidence on record indicates that during quarrel between the appellant and the deceased, the appellant dealt a single blow by means of a kati on the backside of the leg of the deceased, which is no doubt caused grievous hurt, and the weapon used is a dangerous weapon. I am of the humble view that it would not be a case under Section 304 Part 1 of the Indian Penal Code, and it would be a case under Section 326 of the Indian Penal Code. Accordingly, the conviction of the appellant is altered from Section 304 Part 1 of the Indian Penal Code to 326 of the Indian Penal Code. Since the appellant has already remained in custody for 4 years and 7 months, by now the sentence is reduced to period already undergone. The appellant shall be released from judicial custody if his detention is not required in any other case. You have been appointed as amicus curiae or from the legal aid?
Amicus curiae.
So put a note of appreciation and by 7,500 is to be paid to him. And also Mr. Misra's, vary that pencil. P26 IPC period already undergone. Yes.